Humphrey's Executor decision. The Supreme Court's opinion in the Trump versus Slaughter case ended the status, essentially, of independent agencies such as the FTC. And the question for this panel is what this decision will mean for the FTC and more generally for the structure and substance of antitrust enforcement. We have a great panel to discuss this issue, including two former FTC chairs. Bill Kovacic is the Global Competition Professor of Law and Policy at the George Washington Law School and a former chair of the FTC and held many other positions at the FTC prior to that. Maureen Ohlhausen is the co-chair of Antitrust and Competition Practice at Wilson, Sonsini, Goodrich, and Rosati, a former acting chair of the FTC, and also held many other positions at the FTC before that. And Larry White is the Robert Kavesh Professor of Economics at the NYU Stern School of Business and a former chief economist at the Antitrust Division at DOJ.
Tom, let me add. After that, I was a board member of the Federal Home Loan Bank Board, and in that capacity, I was holding a Slaughter-like position nominated by the president, confirmed by the Senate, sitting as a Democrat on the Federal Home Loan Bank. So I've got some appreciation for this issue of the independent agencies as well.
So when the Humphrey's Executor decision came down, there were many predictions of dire consequences, starting with Justice Sotomayor in her dissent, in which she predicted the ruling would, quote, "The ruling promises to unleash only chaos," but she was not alone. Many other people were predicting dire consequences. Let me start with you, Maureen. What was your reaction to those predictions?
Well, I thought the outcome of the decision was entirely predictable and was long foreseen coming down the road right at the FTC. I think chaos, well, particularly for antitrust, that I think is very overblown. Unusually, in some ways, for antitrust, we have dual enforcement at the federal level. We have the Department of Justice Antitrust Division. So that doesn't mean that, oh my gosh, antitrust enforcement stops in the US. And I will mention that in the, so right now we have an agency that says we are, part of the executive branch. There were only 2 Republicans on the commission. There's no Democratic commissioners. But I'll remind people that in the Biden administration, we had a very long stretch where there were only 3 commissioners who were all Democrats and no Republicans. And I don't think people would say that caused chaos, at least not for the reason that Sotomayor is mentioning. So I think it's sort of an overblown. I can't speak for other agencies. I don't know them as well. But I would say for antitrust enforcement. Now, certainly one of the things that we're seeing is the states get much more active in antitrust enforcement, and I think that could cause at least some dissonance. I don't know if I would say chaos, but some dissonance if we end up having very different state antitrust enforcement versus federal antitrust enforcement.
So, Bill, what do you think will be the consequences of this decision in the short run and maybe in the long run for antitrust?
No, thanks, Tom, and thanks for putting the session together. Really delighted to be here. Some of the short and middle term effects, it's the end of the bipartisan multi-member decision-making model. So the FTC is going to gravitate in the direction, I think, of a single administrator because the board configuration, the purpose of having the board, the purpose of having the protection against removal except for cause will be gone now. And I think we'll see the death of the bipartisan multi-member decision-making model. That will be one. Administrative adjudication as a mechanism for decision-making at the FTC, a mechanism that's had some important consequences over the years, is also going to fade away. I don't see how you can have a board having legitimacy from a due process perspective or from a broader perspective of public administration, I don't see how you can have the adjudicators function if the president can fire them due to policy disagreements, with that hanging over their heads. So that's going to die too. I think it's going to trigger an examination of whether you should have two competition agencies or not. There are a series of dominoes that are going to start to fall. They might not fall immediately, but they're going to fall. And one of them is the point that Maureen mentioned before. We have two federal competition agencies in largely the same policy domain. My prediction is that by the end of the decade, we'll have one. That will be the Department of Justice, that the FTC's competition policy functions will be folded into the department.
Larry, from your point of view, having been having worked at the Antitrust Division, what do you think will be the consequences?
Well, again, I don't think we're talking about chaos here. There is going to be this period of uncertainty. What is the government organization chart going to look like? Until what Bill has predicted happens, who does the head of the Federal Trade Commission report to? There's not will it end up looking like something like the Environmental Protection Agency, where there's a single administrator? The EPA is not part of one of the cabinet secretary organizations. The at least for a while, the Federal Trade Commission and the 15 or so other brand name boards and commissions could end up looking like that. What happens to the consumer protection aspect of the FTC is yet another question. Indirect consequence that has antitrust implications, the Surface Transportation Board, yet another one of these agencies, the successor to the Interstate Commerce Commission, which, as we were reminded yesterday, set everything in motion back in 1887. The STB has merger approval authority as well as price regulation authority vis-a-vis railroads. I think there may be a little bit with respect to trucking, but major all railroad mergers have to be approved by the STB. Well, STB is affected by slaughter. I could well imagine STB being abolished sooner or later, and the merger authority for railroads and the regulatory issues of appropriate pricing, whatever that means, getting folded into the Justice Department. So there's going to be a lot of things moving. They're going to move slowly. Congressional committees are going to get involved. And Tom, you and I were talking about this yesterday. Congressional committees are reluctant to give up authority. We've seen that already historically. The CFTC, another one of these commissions, the Commodities Futures Trading Corporation, continues to be in existence largely because, and the two agriculture committees on the Hill, the House and Senate Ag committees, didn't want to see the CFTC, which had started out primarily regulating farm futures, wheat, corn, soybeans, et cetera, and metals, and reported to the Ag Committee, didn't want to see that relationship disappear. So CFTC has never been merged into the Securities and Exchange Commission, yet another one of these things, because of congressional resistance. Interesting question, what happens the FTC, as you two know, reports to a different committee, the Commerce Committee, I
The
think?
Commerce Committee.
Commerce Committees, whereas Justice reports to the Judiciary Committees. So some interesting dynamics there.
Yeah,
as well.
I think that's so important, Larry. The great insurance policy for the FTC in the past, when the issue of dual jurisdiction came up, was always the fact that the Commerce Committee was not going to give up that portfolio without getting something equivalent in return. And they fought to the death to make sure that the FTC's competition authority wasn't given to judiciary, because all of the things they got because of the FTC's authority, money, prestige, other benefits, would have disappeared. That always was the great protection for the FTC. I think with the upheaval that's taking place now, there'll be reconsideration of how to compensate commerce for the loss of the FTC's oversight.
So even with all of that, your prediction is that within 10 years, they will be, the FTC will be merged, or at least the competition part.
When we have this conference in 2031, we'll have an FTC that is a consumer agency and a privacy agency, maybe an enhanced AI portfolio, not antitrust.
Could
I
I
wonder
just
what the
wait?
compensation will be.
Yeah.
But-
Could I just mention, in my remarks, I said we've got the antitrust division, they can enforce antitrust law, but the FTC also has this somewhat undefined or maybe defined in a way I don't agree with, but certainly untested authority of unfair methods of competition, right? That the antitrust division doesn't have. And I think that's one of the questions, which is that something that Congress or the courts will want to preserve? So when you read Justice Gorsuch's concurrence, it's very clear that the next battle with the FTC is going to be with this very broad authority that Congress has given. What is an unfair method of competition? The legislative history talks about it and kind of says, well, it's somewhere beyond the Sherman Act. I'm not sure that that would meet major questions doctrine as interpreted today. So I think that's one of the questions. Is there something that the DOJ can't do that people want the FTC to be able to do, but is that something that's palatable, is that's acceptable? Personally, for a long time, the FTC has stayed away from that authority after a series of court losses. They lost 4 appellate decisions and 1 district court decision where they tried to argue a very broad interpretation of unfair methods of competition. One of the things was the court said, well, you don't even have a statement that articulates it. So now there's a statement that the previous administration put out, but that's still on the books. It's extremely broad. You don't have to define markets. You can be in violation not because of what you did, but if you have a practice and then some other people start that practice, then maybe it's bad for markets overall, so it's going to be prohibited. So there's a lot of challenges, I think, to that extremely broad interpretation of unfair methods of competition. So just putting that out there as, what do we mean by antitrust? Does it also include
So,
this?
I mean, there are 3 things that it seems to me the FTC has that the DOJ doesn't have. This unfair methods of competition, the internal adjudicatory process, and the 6B studies. All 3 of them, I think, have been, at various times, controversial. So if you look forward, especially if you look at a merging of these 2 agencies, or the 2 competition parts of the agencies, what do you think is going to happen to those 3 things?
I think it would be a desperate shame if the research and information gathering power were to die. I would think that could be absorbed by the Department of Justice. That's a function they could carry out. There have been so many instances in which the exercise of that authority has been a catalyst for useful legislative reform. It's informed our understanding of a number of competitive practices. It is the core element of competition policy research and development that we have built into our system. To put that R&D lab to sleep would be a horrible loss in the field. So I would expect that would carry on. On Maureen's really good point about Section 5, I think it founders. I think it's always been an unsustainable part of the agency's jurisdiction. The concept from the beginning that this administrative body would adjust the boundaries of doctrine, moving them outward to encompass new forms of practice, was inherently unstable. Because of the feedback loop that develops within the industry, coming back to Congress and saying, look at what they're doing something unprecedented, the answer would have been, yes, that's what we told them to do. The response instead was to look at the FTC and said, how dare you do that? Go back and keep doing that because we gain benefits from this unvirtuous feedback loop. Keep doing it. It made you wonder whether or not you could sustain it. And the last barrier was the courts never trusted it either. They didn't believe they should defer to this administrative body. Their view was if these federal trade commissioners were any good, they'd be sitting up here on the bench like real judges, like us, instead of being at this minor league organization. So I think from the beginning it was not sustainable. So I see that disappearing, but the thing I would hope would survive, if there is that merger, is the R&D function.
Let me echo that. I was the chief economist at the division in 1982-83, and there was a clear, call it culture, tradition difference between the economists at the division, the economists at the Bureau of Economics at the commission, and already then they had a working paper series under Mike Scherer. They'd done a lot of interesting research. We just didn't have the budget. We didn't have the capability. We didn't have the mission. It just wasn't there. It would be a shame if it died at the commission. Whether it can survive in the Justice Department, given the culture there, that's a separate question.
I just wanted to mention the administrative litigation function at the FTC. I agree. It's on crumbling ground and has been for a long time. And Trump versus Slaughter certainly took a big chunk out of it. But at least in modern practice, it was a way for the FTC to move antitrust doctrine. So it was not unfair methods of competition. It was, Sherman Act doctrine forward in a way that led to some really great improvements in antitrust law, and that got recognized by the Supreme Court. So North Carolina dental case was a good example.
What a great commission decision, too.
Yes, written by this guy here. But it was a long outcome. So it wasn't like just sprang out of nowhere. There were, efforts and workshops, reports on the state action doctrine, things to create test cases, things like that, so that the research function led into the enforcement function that led into the administrative litigation function in a way that actually, I think, had very good outcomes. But not to say, that it doesn't mean it might potentially now have constitutional infirmities, but it did have some benefits.
What I found so desperately disappointing in reading this ponderous set of opinions in Slaughter is there's no discussion at all about what you give up if you cast aside the restriction on removal. No discussion at all. Joni Mitchell famously said in Big Yellow Taxi, "Don't it always seem to go that you don't know what you've got till it's gone?" That's not always true, but it's certainly true here. I would have expected that there would have been at least a tepid effort to say, by the way, this is what we're casting aside. And a recital of the benefits that Maureen just mentioned and the considerable improvement in performance over the past 25 years would have, I think, caused a person to pause for a moment. I think as academics, you don't necessarily expect someone to agree with you, although you hope they would. What you hope is a fair engagement on the merits of your argument. If you do that and you reject my argument, I've got it. That's your job, you decide. They didn't do that here. It's as though they felt uncertain about whether or not that kind of inquiry would lead them to the destination that they had so much predetermined. And it meant that you missed all of these developments. You can say that at the current time, the FTC has come closer in recent decades to realizing the vision that Congress had in mind in 1914. It seemed to me that's exactly the wrong time to give up on that vision, at least with a proper debate about what was disappearing. There's not a hint of that in the court's decision.
Well, let me kind of pursue that at least in a slightly different way. I mean, the common narrative is that the independent agencies are are in some sense apolitical. At least that's a common narrative in the press. But we kind of have a little bit of a natural experiment here. How have the FTC, in terms of actual cases and stuff, and the Antitrust Division behave differently? Can you identify one of them being more or less apolitical, more or less partisan? Over time, not just this, I'm not talking about this, just over time.
I think you point to one of the great straw men who have haunted the debate about independence. When Congress talks about independence, when it mentioned independence in 1914, it didn't mean independent from it. It meant independent from the other end of Pennsylvania Avenue. It means as a practical matter, and maybe you recall this, Maureen, in your own confirmation proceedings, I recall mine, there's a question that's a stock question, which is, you understand, don't you, nominee, that you are an arm of Congress? The correct answer to that question is, yes, Senator, with absolute clarity. The wrong answer is, oh no, Senator, we're independent in the fullest possible sense. They'd probably say, why don't you step outside for a while and think about that? And when you're ready to discuss it further, come back in. Congress meant that the Congress would be the point of political control. There's a wonderful colloquy in the 1914 legislative debates where Albert Cummins is one of the enthusiastic supporters of the FTC, is speaking with one of his colleagues, and the colleague says, this is really broad authority in this Section 5 business on unfair methods of competition. Doesn't that make you nervous? And Cummins said, oh no. We created the Federal Trade Commission, and if we felt that it strayed from the aims that we had in mind, we can destroy it. His words, destroy it. What Cummins was saying is, if this wobbles and goes off the path, we're going to do something about it. And they've always been deeply involved in many ways in the decision-making of the agency. And you can point to matters where because they put gun at the head pressure on the agency has brought cases like In re Exxon, which many people in this room would remember. So there's always been political involvement, but the most intense has been from the Congress by design, not from the White House.
This is not directly FTC, but there are other independent agencies where clearly things have gone back and forth depending on the particular administration that had appointed the chair and most, if not all, of the members. The Federal Communications Commission, which many people in this audience will be familiar with, going back and forth on net neutrality, depending on which administration, which chair. Another independent agency, the National Labor Relations Board, NLRB, going back and forth on issues a little closer to my home, whether graduate students are considered employees of a university and therefore can legitimately unionize, enter into collective bargaining, going back and forth. So the independence of executive branch can be very idiosyncratic. When I was at the division, Bill Baxter was the Assistant Attorney General for Antitrust. He had a pretty clear independent mandate. The Attorney General at the time was recused on some important issues and really had no interest in antitrust. Bill was able to be his own person, especially in something like the AT&T breakup. that he believed very strongly in, facing opposition from the Department of Commerce, from the Department of Defense, and was able to withstand those sorts of things. He was independent. So these sorts of things are very idiosyncratic.
One thing that I wanted to mention was we can't look at the FTC solely as it was created, over 100 years ago. Since that time, it's been given a lot of new powers that are much more like executive powers. So the ability to go into federal court and get an injunction, the ability to get massive, even after the AMG decision, where the unanimous Supreme Court said, no, you don't have that redress authority. But still, the FTC now, through its enforcing rules and COPPA and ROSCA and things like that, is going after massive penalties. And in the previous administration, very much they said we are political. They were at the White House. Biden is signing things and he's handing the pen to the head of the FTC, right? And Humphrey's executor was still good law then, right? So I think another one of the things that Justice Gorsuch's concurrence says is, Congress, you gave a lot of power to the executive branch. You're going to have to deal with. You're going to have to think about that. Right, and I think, so when Congress thought it was going to be under their control, but that also doesn't mean they can endlessly sort of hand over powers and say, oh, but there are powers, right, forever.
Well, do you think they're going to try to take it back? Congress, slowly over time. But do you think there will be a move to do? I mean. Or are they not capable?
How about the previous panel? Should have asked them. That would have been an interesting question to ask the previous panel.
I think there'll be a lot of discussion and consideration and measures to take some of it back. For example, to impose quorum requirements that mean that you can't go on forever without a full body of members of the agency. Something that tries to establish an action-forcing mechanism that tells the White House, you have this amount of time to send up a name, that tells the Congress you have this amount of time to act on the name, that you can't simply drift indefinitely with a vacancy, 2 vacancies, 3 vacancies, without doing something about it. That would be one, is to change. And the FCC has a quorum requirement built right into the statute. So that would be one thing. You might see efforts to change some of the procedures to make the decision-making process a bit more accountable, if not directly to Congress, but to others. Pull the FTC within the ambit of the Tunney Act when it comes to the review of settlements. Mandate closing statements every single time the FTC uses compulsory process and then decides to close a file. Give third-party rights to outsiders to attack administrative decisions with respect to settlements or decisions not to act at all. That's the European model, where if I'm a complainant, I can go to court and say that was a bad deal. You should have taken some action. You should have done more than that. I expect we'll see some consideration of these other tools.
That's a Tunney Act. That's a Tunney Act.
That's a Tunney Act-like solution. Yeah.
Well, let me open it up to questions from the audience, if there are any. Why don't you wait for a microphone? Assuming, yeah.
I was wondering if you could talk a little bit more about the role of the minority commissioner, just because I think that it's been important in the history of the FTC. And when both of you were chair for some period of time, you did not seem to like party line votes very much, and did a good job into working with the minority commissioners. And then Maureen did a great job as a minority commissioner, getting things through as a vote and using her vote for leverage. So I was wondering if you have thoughts on what the ideal role of the minority commissioner is, and whether we'll ever get back there again.
So when I first started at the FTC, so I was a Republican appointee of the Obama administration, right? So I was minority commissioner. And I went to an event at my old alma mater, George Mason Law School, and someone said to me, "Are you up there, writing a lot of dissents?" And I said, I kind of like to win. And if you are dissenting, you are by definition not winning. So I would prefer to engage with my colleagues to get to a point where I don't have to dissent, where we can narrow things down or change theories or what have you to bring a case that I can support. And there were norms at the time that I think really supported that kind of engagement. And if you talk to the bureau directors, David Vladeck or Debbie Feinstein, they've acknowledged that was an important role. And then, occasionally the minority commissioner, you can't get them on board. And they write a dissent, and sometimes that becomes, like in the Qualcomm case, right, that becomes the decision, that is consistent with the ultimate court decision. One of the other things that I think is important is on the quality and the success of the enforcement action. So I just did it was very limited, but I did a little survey about how did cases brought by the FTC, antitrust cases, fare in court, whether they were bipartisan or not. And the bipartisan ones were a lot more successful, and the ones that were just a single party were a lot more likely to get struck down, which I think is important because we're using limited government resources and suing companies who ultimately were found not to have done anything wrong. So I think trying to calibrate enforcement better to be successful is an important goal, and bipartisanship can be part of that.
When I was chair, I thought that having 5 commissioners was 4 too many. But I knew that it was in the statute, and I did see benefits from it, even though some interventions were uniquely irksome. So one thing you need in the appointments process is you need a willingness of the president and the Congress to probe as best they can some instinct for collegiality. And it's a collegiality that says, if you're going to disagree, let's keep it on the merits. Let's play the ball, not the man, in the sport. That's really hard to create. The role of a non-chair commissioner is exceedingly frustrating. You have a nice office, you have a good title, but you don't have a lot of power as such. And I've been told it's similar to being in a band where for years you've been the Supremes, but now suddenly it's Diana Ross and the Supremes. You used to be the Police, but now it's Sting and the Police. The rest of the Police didn't like that so much. Neither did the other Supremes. So you have the front person out there who's getting all the attention anymore. That's inherently frustrating. It means that you have to exert a lot of time. Every week I went to my colleagues and sat down with each one of them for an hour and said, what should we be doing? I'd tell them they were doing a great job. We couldn't live without them. And I'd ask for their views about what we should be doing. It was not entirely manipulative. And I know that in some instances, if you invested the huge effort in doing that, you elicited perspectives on strategy and tactics that were very worthwhile. John Leibowitz, for example, gave me wonderful advice of how to deal with pharmaceuticals and what we called reverse payments, and ultimately achieve significant litigation success along with policymaking and research successes. That was a great benefit. I found that if you were willing to listen, which is an essential part of it, suppress your own sense of self-worth, and listen to colleagues, you would create an environment in which that would work. It was exceedingly useful, I found, to have the different points of view. And as Maureen was saying, if you could muster unanimity, that was a proxy to the outside world that you had achieved a result that was legitimate and broadly based. There's one thing that gets in the way, and that is the Government and the Sunshine Act. The Government and the Sunshine Act means that if you have more than 2 members of the board speaking together, you have to have an open public meeting. It means you have to go through charades in establishing strategy, charades in going through the regular deliberation. I have to think that there was an enemy of the United States who thought, how can I disable the administrative process in the U.S.? I've got it. It's going to be the Sunshine Act. I served for 9 years as an outside director of the board of the Competition and Markets Authority in the UK. They could not believe it. All of our meetings there were detailed, productive discussions about the political environment, strategy to be chosen, selection of projects. Those were so liberating and refreshing in the capacity of the board to do its damn job, which was to deliberate in that way. You can't do that under our existing configuration. That is a terrible impediment on realizing the full benefits of multi-member collaboration. You have to work with that framework. I don't see that changing. But if you do it, if you're patient, you take and you think very carefully about what your colleagues can bring to the process, and you understand what those things are, you can elicit, I think, a useful degree of cooperation, and Maureen was the great master of that.
As an outsider, let me say, hearing Bill and Maureen talk about a very real good culture, and we've heard Rebecca Slaughter talk about that culture as well. She's written about it in the Penn Regulation Review. But that culture isn't there always. Again, it's idiosyncratic. We saw, if Noah Phillips were up here as a minority commissioner, he would have different perspectives on what it was like during the Biden administration FTC. And again, having served on the Federal Home Loan Bank Board, a 3-person board, 2 were Republicans, the 3rd was other, I was the other, I was a Democrat, and we didn't have that kind of culture. The chair of the Federal Home Loan Bank Board, M. Danny Wall, was suspicious. I was a D, he was an R, and he just was completely suspicious. So this, the cultural thing, it's great when it's there, and we've got 2 very able people who made it happen,
Exceedingly
but it doesn't
able people who made it happen, yes.
Sorry, 2 what?
Exceedingly able.
Oh, exceedingly. Excuse me. Yes, of course, exceedingly. But it doesn't always happen.
You use the right word, Larry. It's culture. It's a norm.
Yeah.
It's not a formal binding requirement, and I don't know of any mechanism we have in the United States to give appointees a full understanding of what those norms ought to be and how, if they're shattered, the mechanism seizes up and it fails.
Yeah.
I think we have time for one last question from.
So I'll start with a statement and then question. I will say, I think it was observed earlier, the jurisdictional aspects of FTC reform. I'm not entirely sure whether the overturning of Humphreys has changed those political dynamics around, Bill, you mentioned the Commerce Committee's, I would say, defense of the FTC as both its antitrust and its consumer protection authorities.
It was a defense of their own patronage prerogatives.
Well,
that was the defense.
I will give you, just for transparency, I work on energy and commerce, so we have certain our own views. The question is, it was remarked yesterday that, it was suggested that perhaps bipartisan requirements on commissions could be violative of Constitution. I guess the question is whether quorum, first we welcome y'all's views on that, as well as whether quorum requirements as well could, again, restrict the president's authority vis-a-vis these agencies and would be equally violative if, as well.
When I listen to the con law enthusiasts for the unitary executive theory, they would answer both of your questions saying both of those are unsupportable. That you cannot have quorum requirements, you cannot have political diversity requirements either. They'd say both of those have, because those get in the way of the president's ability to manage these agencies or to oversee their management. As Christopher Yu was mentioning yesterday, I think that's a exceedingly broad reading of the meaning of the theory itself and its application. It seems to me that the quorum requirement is so fundamental a matter going to the administrative mechanism itself that you could insist upon a minimum quorum to do that. But I see the problem with where the theory, the words and the music of slaughter takes us. And my fear is that now, because it's a constitutional principle, lots of reforms that you can undertake are checkmated as you go one after another, and you end up with a fairly unbounded set of powers where the president can resist all these efforts of control.
Well, let me ask one final question, kind of a summary question. If you had to predict what this decision will do to antitrust enforcement, what over the next decade or even longer, would you say? On the spectrum of no significant change to significant change, where on the spectrum would this decision, what would be the lasting effects of it, the long-run effects of it?
On a scale of 1 to 10, I give it a 7 to 8 in significance. What I think, and there are real costs to having two. There are unmistakably costs to having two. There are coordination costs. There are costs in coherence, in presenting a view to foreign nations, to our own public. Those are real costs, and I admit them. I'm not going to assert that the FTC, within the framework that we've been discussing, has always been a model of good performance. I can't make that argument. I can say that what you give up is an element of innovation and vitality. It's the FTC that brought healthcare into the orbit of competition policy starting in the 1970s and did it in a way that I think has conferred great benefits. It's the FTC that brought to bear the examination of government as a source of monopoly power, government as a source of competitive restrictions. It's the FTC that's been the body that's made the state action doctrine more confined than it was before, and has given real life to the restrictions that have been placed there. It was the commission that did that. It's the commission that did the hearings that had important innovation elements to that. I'm reluctant to give that up. You won't see it right away. You won't see a decisive effect right away. But I think it's been a source of a generally friendly rivalry with the department that's been useful. And I think it was Joanna mentioned before, there's going to be an AI smash-up, an Exxon Valdez moment that means that Congress will pass AI legislation that involves some element of competition, consumer protection, and data protection. Where do you think that ought to go? That ought to go to the Federal Trade Commission. I think it's exactly the wrong time to give that model up right now.
Maureen?
I fully endorse what Bill said. I wouldn't say 7 or 8. I would say it's more like a 4, right? 5 maybe.
I'm an easy grader.
Well, the thing is, I don't want to denigrate the contributions of the Antitrust Division, right? So I'm not in any way saying the Antitrust Division, isn't an effective antitrust enforcer. But in the innovation of moving antitrust law forward in a pro-competitive, pro-consumer way, the marrying, and we mentioned this, the marrying of this policy function, this research function, with the FTC's then eventual enforcement authority has led to really, really good outcomes. And some of it was through the administrative litigation as well. So if that is not replicated somewhere, so if the FTC is like totally taken, kind of out of the game, I think there'll be a loss there, because that ability over time to develop the thinking and then the cases and then eventually win in court has really, I've sat there and there was a state action case where a court cited something, and I thought, I remember sitting in my office when I was in the Office of Policy Planning writing that. Yeah. And it went in a report, and it eventually ended up in a case decision, right? So that continuity has really, I think, been a good thing.
I'm with Maureen on this, a 3 or a 4, though I consider myself a pussycat when it comes to grading.
I'm a doormat.
Well, But there is room within government for diversity. I don't want to use the word monopoly when we're talking about government, but there's just, good ideas should have multiple places where they can land. If there's only one place where a good idea can land, when times are good, it's going to land and everything's going to really go forward. But if times aren't so good and whoever is in charge of that particular agency says, nah, I don't think it's a good idea, you've lost something. So there is room for diversity, and we've been talking about these cultural things. It's going to be a loss if that culture is lost.
We've talked so much about innovation and the conditions that give you innovation.
Yep.
I'd hate to give up one of the sources of the innovation right now in our national experience.
Well, thank you all very much. This has been it's been a great panel. I appreciate it. Thanks.
Thanks, Tom. Thank you. Great questions too, Tom.
Of course.
I actually came away with a slightly different point of view than I had going in.
Yes.
That I guess my initial thing was it wasn't going to make very much difference, for example.
Thank you. Thank you. Thank you.
So I was influenced by that.